All right, good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner. We ready to learn some stuff tonight? Aloha. See some early birds over on YouTuber. Thanks for all the birthday wishes, folks. Welcome to the new version 5.0. Oh, man. So tonight I'm going to cover some stuff it seems to be quite prevalent, even though, Chris and I have basically been teaching this stuff. Well, not just teaching, but learning, right? We've been learning and teaching as we go as well for the last 4 years, since February 2017. So I've found some stuff that shows us how to do this, which I found this after Chris was murdered. So, but this is the key to redressing our grievances in the proper form of a petition. And one of them that I'm going to cover first tonight is the election petition. And then I'll jump back up to the form, again, covering the forms of petitions. So obviously we have to cover the law first, right? Yep, sorry, wasn't here Friday. I went camping. I left Thursday morning and came back Saturday or Sunday afternoon. So it was a really, really good time. It was nice and cool up there. Still got warm during the day, but a decent, I don't know, probably 10 degrees cooler, if not more, but definitely at night, a little more cool up there where we went. Right on the reservoir, big body of water up there. Literally like a stone's throw to the water. It was not very far. So good times with some good people. Thank you everybody that came to that. It was a good time. So let's see. Let's jump into some law, because that's what we need to read first and have a basic comprehension. Return to these fundamental principles of law. Oh, where are you? Let's start with, I know this is the Idaho Constitution, but the fact is these are our rights. We talk about First Amendment, or Article the First of Bill of Rights. The First Amendment guarantees freedoms concerning religion, expression, assembly, and the right to petition. Now, not many people are aware that those two actually go hand in hand. It's actually the right to petition is how we call them into assembly. Okay? They kind of go hand in hand. Yes, I get the fact that we have the right to peaceably assemble. But as we can read from the Idaho Constitution, Article 1, Declaration of Rights. Now remember, this is our state of being, our body politic. This is the law. Right here, Article 1, laying down the law. Now, we'll look at this right here, Article 1, Section 2. Political power inherent in the people. All political powers inherent in the people, period. All of it. Not some of it, not most of it, but all of it. This might sound familiar from the Declaration of Independence. Government is instituted for their equal protection and benefit. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Now, this is one of the key parts here. And the other part that I'm going to be referring to is, with certain employers requiring as their policy, it is not a mandate. Mandates, first of all, are from the judicial branch to a lower court. Otherwise, a mandate's where two guys go fishing. That's a mandate. Okay? But when we have a corporation or a business that violates the policy violates our rights, that's a right to petition the legislature, as it says right here. And no special privileges. Okay? The privileges we're talking about here is a business license. It is a privilege to do business in our communities. And being that all political power is inherent in the people, and that we have all of the power to alter, reform, or abolish anything at any time we deem it necessary, right? Whenever they may deem it necessary. Listen to what it says here, as it is written. No special privileges or immunities shall ever be granted. Okay, that's the business license. That may not be altered, revoked, or repealed by the legislature. So clearly, the law, our right, dictates that we have to go to the legislature to revoke their business license, their privileges. Okay? This is the law, not a statute, not a code, not a rule of procedure. This is actual law. Okay? This is the common law, the law of the land. Now, we're going to come down here. Right of assembly. Now, look at the verbiage here in this right. The people shall have the right to assemble in a peaceful manner to consult for their common good. There's a semicolon here. To do what? To instruct their representatives and to petition the legislature for the redress of grievances, not the judicial branch. I know that we've all been taught that we go to the judicial branch for everything. No, that is not what it says as it is written right here. This is the letter of the law as it is written, not what we were taught. We weren't taught that we are supposed to go to the legislature for the redress of grievances, were we? Imagine that. Who controls the judicial branch? The bar. That's why they want us to go to the judicial branch, so they can remain in control. But see, if all political power is inherent in the people and that power is exercised through the legislature, well, now, this is how we take our power back. Because as it is written right here, to instruct their representatives, because they are the servants, right? I mean, well, let's go to the Idaho Code, the Ethics in Governments, Title 74, subsection 201, transparent and ethical government. Oh my gosh, we have ethics in government? You darn right we do. Morals. Chapter 2, I know it says open meeting laws, but watch this. Subsection 201, formation of public policy at open meeting. Wait a minute. Public policy. It's policy. It's not law. But let's see what it says here. Formation of public and open meetings. The people of the state of Idaho in creating the instruments of government that serve them. What is the instrument of government? That's the Constitution. The Constitution creates government. Period. It's a piece of paper. Government is a piece of paper, literally. But what does it say? Creating the instruments of government that serve them. Oh, wait a minute. If they're the servants, then that makes us the master, because that's a reciprocal to servant. Masters and servant. But what does it say here? Do not yield their sovereignty to the agencies so created. This totally destroys the sovereign citizen, because they are the citizens. The people retain their sovereignty. Now, when one of the people gets elected or appointed into a position of public trust pursuant to Article 6, Clause 3 of the Constitution of the United States of America, that instrument of government, we the people require every single one of them, from the legislative branch, executive branch, and judicial branch, so all of government, both state and federal, to be bound by the Constitution. Now, this goes back to the Law of Nations written by Emery D. Vattel. The definition of a citizen are those that are bound by the society. Well, what the heck do you think Article 6, Clause 3 is? It's a requirement that they all be bound. They become a citizen and give up their sovereignty in exchange for privileges and immunities. The same thing with corporations. Okay, and I'll show that right here. Let's finish this. Therefore, the legislature finds and declares it is the policy of this state that the formation of public policy is public business and shall not be conducted in secret. They make policy. That's it. They don't make law. They make bylaws, policy. And policy only applies to those that are bound by it. That's exactly what this is saying. That the people do not yield their sovereignty to any part of government. Period. That's fundamental and principally. Okay, it's part of the fundamental law. So, let's go back. Oops, we're going to go back over here. We're going to go back to this instrument of government that's supposed to serve us. Now, you'll notice here that this is Article 11 for corporations, public and private. Oh, we're private. No. You might be privately owned, but the second that you open your doors for business, you become public. You act in interstate or foreign commerce. You're in the public. Yes, privately owned. I get that. But there is a, right here. Okay. Number 7, Section 7. Acceptance of the constitutions. No corporation in the municipal corporations of the existence of the time of the adoption of this constitution shall have the benefit of any future legislation without first filing in the office of the Secretary of State an acceptance of the provisions of this constitution in binding form. That's right. In our form of government, we require all corporations, public and private, to be bound by the constitutions. No ifs, ands, or buts. There it is, in writing, pursuant to the letter of the law of the land. Okay? Now let's look at Section 8. Now this is very key for what's going on out there right now, which I just went out there to Meridian, Idaho, and walked the line there with everybody. And man, there was over 1,000 people there. Okay, pay attention. This is for you folks right here, right now. Now, the right of eminent domain shall never be abridged, nor circumscribed to prevent the legislature from taking the property. Pay attention to what it says here under domain, eminent domain. Taking the property and franchises of incorporated companies and subjecting them to public use. The same as the property of individuals. Well, individuals are those that are members of incorporated companies. In other words, they can't touch the people in the private. And the policy powers, because I'm going to pronounce that correctly, it's not police. There's no way that that word can be pronounced police. It's police, as in polar ice caps, or police, like head lice. No. And I've already proven this, showed the history of some of the very first constitutions, use that actual verbiage, police, in reference to the legislature. Policy. That's a C-E, A-E-I-O-U, and sometimes Y. You change that E to an I or Y, you got policy. But if you pronounce it phonetically, policy, it's a 3-syllable word. Now, and the policy powers of the state shall never be abridged or so construed as to permit corporations to conduct their business in such manner as to infringe the equal rights of individuals or the general well-being of the state. What that means is the legislature cannot grant privileges or allow them to conduct their business in such a manner as to violate our rights. This is why we require them to be bound by the constitutions. Okay? So this is where we go back to petitioning the legislature for the redress of grievances to revoke their business license. Okay? This is how it's done. Right there. No special privileges. Immunities shall be granted that may not be altered, revoked, or repealed by the legislature. So we do a petition to the legislature. Now, this is where standing, or status and standing. Status, you'd have to be an individual member of the corporation. When that corporation says, oh, well, we've got a policy that says you have to do this. Well, if it violates your rights, now this is where we have to go back to, well, what rights does it violate? How about this one? All men are by nature free and equal, and have certain, and they're actually unalienable, not inalienable. Those are civil rights. We're talking natural rights, right? All men are by nature. This is natural rights from the laws of nature and nature's God that the Declaration of Independence declares that is supposed to be self-evident, among which are enjoying and defending life and liberty. You might recall that from the Declaration of Independence. These unalienable rights, among these are life, liberty, and the pursuit of happiness. This is just reiterating the Declaration of Independence, except they used the wrong word. Inalienable versus unalienable. Because Natural rights and civil rights are considered our property. An aggregate of guaranteed rights is our property. And that's why it's called a trespass. That's a real trespass. When you trespass on our property, a common law trespass. Okay? But see, that's what it says. Defending life and liberty, acquiring, possessing, and protecting property. Pursuing happiness and securing safety. So, fundamentally and principally here, by nature, we are free as opposed to being slaves, and equal as opposed to having, what is it? No man or set of men are entitled to separate emoluments or privileges from the communities. That's a fundamental principle of our Republican form of government that can never be allowed. That's foreign to our form of government and repugnant to our law. We've already said that. Here it is again. Now, the next rights that it violates is religion, right? Guarantee of religious liberty. Another one of those liberty interests. The exercise and enjoyment of religious faith and worship shall forever be guaranteed. That's because it's among those guaranteed rights, unalienable rights. And no person shall be denied, and that should say, and no man shall be denied any civil or political right. Although person, okay, persons don't really have natural rights. Person is McDonald's. Person is governor. There's still a man in his proper person acting as a governor. Okay. Anywho, privilege or capacity on account of his religious opinions, but the liberty of conscience hereby secured shall not be construed to dispense with oaths or affirmations, or excuse acts of licentiousness, or justify polygamous or other pernicious practices. How about them pernicious practices? Business practices? Inconsistent with morality, or the peace or safety of the state of being free and equal and having the liberty of conscience, which means we have the right to think for ourselves, morally, ethically, nor to permit any person, organization, or association to directly or indirectly aid or abet, counsel, or advise any person to commit the crime of bigamy or polygamy or any other crime. Would it not be a public offense for a corporation to make a policy that violates our rights? Yes, indeed. That's any other crime. No person shall be required to attend or support any ministry or place of worship, religious sect or denomination, or pay tithes against his consent, nor shall any preference be given by law to any religious denomination or mode of worship. Bigamy and polygamy are forever prohibited in this state. And, look at this, and the legislature shall provide by law for the punishment of such crimes. All be darned. But the key part, nor to permit any person, organization, or association to directly or indirectly aid and abet, counsel, or advise any person to commit the crime or any other crime. So whoever's telling these employers that they have the authority to dictate to their employees that they have to do something other than what's in the terms and conditions of employment, what are the duties to perform under that emolument? They cannot make a policy that violates our rights, period. Article 1, Section 1 and Article 1, Section 4. Okay? Now, again, back to petitioning the legislature for that. So, for those of you out there that I seen today, medical professionals, and you're wanting to know how to not only effectively defend yourself, but future. This is the way we do this in our republic. Okay, this is an individual right. Only takes one. But if we do one petition, and I'm prepared and offered to prepare the petition, and then all you folks have to do is sign it and file it in the legislature and demand an investigation to verify your claims that business, that corporation has made a policy. It's not a mandate. So stop using the word mandate. We're confusing that with mandatory. Mandatory and mandate are not exactly the same. They are, but they're not. When you're talking about a mandate is actually, again, from the judicial branch to a lower court. We're not in the judicial branch. And this definitely isn't from a higher court to a lower court. This is a corporate policy, because that's all they can make is policy. And then, theoretically, they're attempting to alter the terms and conditions of your contract of employment with them after the fact, and then threatening to fire you if you don't. Now, it's quite odd that a medical facility who, receives a subsidy, Medicare, Medicaid, that's federal dollars, tax dollars. We pay into Medicaid and Medicare, right? When we pay taxes. That's right. That's taxpayer dollars. We have the right to provide oversight of that. We also have the right to revoke their business license for making a policy that comes in conflict with our right of liberty of conscience, which is the right to think for ourselves and determine whether or not we want those medical services or any other kind of services provided by public servants. We're not supposed to allow that. But they prey on our ignorance, folks. And I can guarantee you, you medical professionals out there, you come together and you sign on these petitions, and we file this sucker. Again, I don't have a cause of action. I'm not a medical professional. I don't have anybody forcing me to take the jab or any kind of pharmaceutical drug. Okay? Because remember, fundamentally and principally, we, the people of the state of Idaho, grateful to Almighty God for our freedom to secure its blessings, God's blessings, and promote our common welfare, do establish this Constitution. Our common welfare is to defend against corporations that may manufacture a product or provide services that may cause injury, loss, or harm to the people. Fundamentally and principally, that's the general welfare clause, is to defend against corporations or businesses who manufacture a product or provide services that may cause injury, loss, or harm to the people. Now, those people that may be injured or have a loss or cause harm to them have a right to a cause of action. If your job is being threatened because of it, whatever it is, whatever the policy is, and you have the right to think for yourself, you have the right to be free and equal, well, you have grounds You have standing to claim your right to a cause of action and go to the legislature, demand an investigation, and revoke their business license. I can guarantee you real quick, they'll drop that policy the second the legislature investigates the laws of its creation. And receiving federal funds, that's a big no-no. Technically speaking, pursuant to Article 4, Section 4, okay? We'll look at that real quick. What? Where the heck did it go? Oh. Article 4, Section 4 of the Constitution of the United States of America. The United States shall guarantee to every state in this union a Republican form of government. Wait, it doesn't say democratic, does it? And shall protect each of them against invasion. Now, here again, on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Now, again, we've all been taught that domestic violence has to do with family, domestic relations. No. And I'll show you again, just real quick. Go over here to that C explanation. What does it mean to guarantee a Republican form of government? What does domestic violence mean? The first clause of this section is somewhat different language. It was contained in the Virginia Plan. What's the Virginia Plan? Oh, boy. Introduced to the convention, was obviously attributed to Madison. Through the various permeations into its final form, the object of the clause seems to clearly to have been more than an authorization for federal government to protect states against foreign invasion or internal insurrection. This would be Luther versus Borden. Oh, wait. Is that the one it is? Oh, this is June 11th, supporting Madison's version pending then. Okay, he's talking about the formation of this. Okay. We'll go down further. A power seemingly already conferred in any case. Legislature can't be convened. The executive. This is internal insurrection. This is domestic violence. Internal. It's not foreign. Unlike the bar, that's a foreign invasion. They've invaded our form of government. It's also internal insurrection because they fundamentally altered our form of government, which is internal insurrection is about overthrowing the Constitution and warring against the people. What do you think they're doing? They're warring against the people. You don't do this, you're fired. No, I don't think so. You do that, and I'm going to revoke your business license. How about that? I'm going to own you. And no one can now resurrect the full meaning of the clause and intent which moved the framers to adopt it. Oh, really? You talk about it here. And no state in it ought to have it in their power to change its government into a monarchy. You can't really seem to, oh, look at that. Again, on July 18th, that's my birthday, when Wilson and Mason indicated their understanding that the object of the proposal was merely to protect states against violence, Randolph asserted. The resolution has two objects. One, to secure Republican government. Two, to suppress domestic commotions. Imagine that. Following speakers alluded to the dangers of monarchy being created peacefully and necessitating the provision. It's exactly what's happened. All right. Now, in Luther versus Borden, okay, the Supreme Court established the doctrine. The questions arising under this section are political, not judicial. in character, and that it rests with Congress to decide what government is established in a state, as well as its Republican character. So when we go to the state legislature and they go, we're not going to do it, we can appeal to the United States Congress to ensure and guarantee our right to petition the legislature for the redress of grievances, no matter what it is. That's called dereliction of duty, when we have the power to instruct them, when we have the power to call them into assembly so that we can redress our grievances. Okay. But as we can see here, it's political, not judicial. This is a political lawsuit. And even then, if they don't want to do that, then we go straight to the executive branch with a criminal complaint, not only against the original cause of action, but against the public servants, the legislature, for dereliction of duty, for failing to protect the people from what may cause injury, loss, or harm to the people. That's one of their first primary fundamental principles of duty. And they don't want to do that. We just tell on them. We roll on over to the executive branch. Okay? So, jump back to the First Amendment, right? Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. In other words, prohibiting the free exercise of the liberty of conscience to think for ourselves, or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for the redress of grievances, which in this case, they left out the legislature, but that's because it's the legislature, and if the legislature can't be convened, the executive. We do not go to the judicial branch. That's not how our form of government works or supposed to work. All right. So now that we know this, that other petition type thing, election petitions. Well, let's go back over here real quick. Mason's Manual Legislative Procedure, 2010 edition. Now, I didn't necessarily know this at first. So this was a learning thing back in, August, I think it was August 24th, 2017, 2018, 2017, 18, right before I went to Washington, D.C. Let's go. I'm going to go over here real quick. Go back over here to the laws and rules. Well, look at that. We got Senate rules, House rules, and joint rules. These are House rules of procedure. We don't just use rules. It's rules of procedure or rule of law. It's always a rule of something, not just plain rule. But Rule 75, House Rule of Procedure. The rules of parliamentary practice set forth in the Mason's Manual of Legislative Procedures. See? Legislative procedures shall govern the House in all cases to which they are applicable, and in which they are not inconsistent with the standard rules and orders of the House and the joint rules and orders of the Senate and House of Representatives. I know a lot of people probably don't even know this, right? But the last time I knew, 70% of the states use the Mason's Manual of Legislative Procedure as their guidebook for dummies for the legislature. There it is in the House Rule of Procedure 75. Okay. Now another one. Let's go with rule number 12, petitions, memorials. Petitions, memorials, and other papers addressed to the House shall be presented by the Speaker. No, that subverts the right of the people to petition the legislature for the redress of grievances. According to Mason's Manual, Legislative Procedure, we have the right to present our own petition. That's right, because this rule of procedure would be subverting the right. So which stands on a higher plane? Constitutional provisions stand on a higher plane than statutes and are mandatory. Now here's the next one in their rules of procedure. Right there. Presentation of petitions and communications. This is in the order of business. After calling the House to order, the order of business for the day shall be as follows. That's right. For the day. Step number 14 of order of business for the day, presentation of petitions and communications. So every day, they have an order of business for the day. We would have the ability to present our petition, whether it's a election petition or any other kind of petition. This is where they go. This is how our Republican form of government works. Our rights dictate that because that's the real law, not the rules of procedure. Okay. I'll go back. Investigations by legislative bodies. Okay, this is Part 10, Investigations and Public Order. This is the Mason 2010 edition. Now, the 2020 is out, but Chris had this scanned in for educational purposes only, right? Investigations and Public Order, Chapter 73, Investigation by Legislative Bodies. The right of a legislative body to make investigations. The right of the legislative body to make investigate. You know what? Make that. Oh, I know it's going to switch on us anyways. Can't really make it bigger. Well, I can for a second. Whew. Might get a little blurry. Investigation in order to assist in the preparation of wise and timely laws must exist an indispensable incident auxiliary to the proper exercise of legislative power. This has also been recognized from the earliest times in the history of the U.S. legislation, both federal and state, and from even earlier epochs in the development of British jurisprudence. The legislature has the power to investigate any subject regarding which it may desire information in connection with the proper discharge of its function to enact, amend, or repeal statutes, or to perform any other act delegated to it by the Constitution. The power and duty reposed in the legislature and in each and every member of both houses thereof is that, both houses thereof is that of preparing and proceeding to enact wise and well-formed and needful laws, and in the preparation of such laws, the necessity and investigation of some sort must exist as an indispensable incident. Legislature, and this is talking about the enactments of laws. Okay, great. But when we get over here, the legislature or committee of the legislature cannot be enjoined from investigating a matter that is under litigation in the courts. The ascertain of pertinent facts, the basis for legislation. There we go. An investigation into the management of the various institutions of the state and the departments of the state government is at all times a legitimate function of the legislature. The right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. So the way this technically would work is when they're not in session, technically speaking, we would go through the committee, right? Because that's committees. We have standing committees. Standing committees are always there. So we would present our petition to the standing committee. And then, according to the Idaho Constitution, you see, now, here's the crazy part, right? Right here, quorum. A majority of each house shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of absent members in such manner and under such penalties as such house may provide. That's right. They can do warrants for arrest for people who don't show up. Once they've been called, they're being paid, right? They were elected to this. They're the citizens. We're the masters. They're the servants. And when they're called, they're supposed to assemble. A quorum being in attendance, if either house failed to effect an organization within the first 4 days thereafter, the members of the house so failing shall be entitled to no compensation from the end of the said 4 days until an organization shall have been effected. But see, the quorum is a majority of each house. And they have to have a quorum to do business, other than smaller number may be adjourned from day to day. Okay. But when it comes to redress of grievances, that requires a quorum. Because again, constitutional provisions stand on a higher plane than statutes, and most definitely their own rules of procedure. They cannot make a rule of procedure that would come in conflict with the Constitution, because one is subordinate to the other, right? Fundamentally and principally, the Constitution was created first, which institutes government. Therefore, that which is created cannot dictate to its creator what the scope and authority of their emoluments are. They have to discharge the duties of their office as we instruct them to do. They're there to serve us, period. End of discussion. That's facts of law, which I've already just previously showed. Okay? So this is a requirement in our Republican form of government that we have a quorum to do business. Now, I want to point this one out here. They do have a privilege from arrest. Senators and representatives in all cases, except for treason, felony, or breach of the peace, shall be privileged. That's right. Those are privileges, not rights. From arrest during the session of the legislature, and in going to and returning from the same, and shall not be liable to any civil process during the session of the legislature, nor during the 10 days next before the commencement thereof, nor shall a member for words uttered in debate in either house be questioned in any other place. This is where the right to freedom of speech comes in. The right to speak freely in debate in either house. But the thing is, they're not free from arrest for treason, felony, or breach of the peace. No man is above the law. So there it is. They're not free from arrest for treason, felony, or breach of the peace. This is how we're going to clean up our republic, folks. Time to start arresting these bad actors in government who trespass the law on our property, an aggregate of guaranteed rights, for treason, for other felonies. Now, just so that we're clear here, where is it? Is it this one? Powers of the government of this state are divided into 3 distinct departments. Oh, wait a minute. The legislative branch, the executive branch, and the judicial branch are departments. We'll get to that later sometime. And no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers properly belonging to either of the others, except as in this Constitution expressly directed or permitted, which it's not. The legislature cannot delegate its power to any man or set of men, or person or collection of persons. No, it's man or set of men, the bar, to write the Idaho Code. That's in Peterson versus Peterson, and why the Idaho Code is not the law. Because the Code Commission has no legislative authority, and the legislature cannot delegate its power. Right there. Cannot do it. I thought it was number 2. No. Maybe. Huh. I could have swore it was right here, but where it says that the Constitution of the United States of America is the supreme law of the land and the states of the Union, blah, 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 blah. Where in the heck was that? I don't know. But this is where it talks about, the legislature has subject matter jurisdiction to create, but within the constitutional limitations, right? Legislature may prescribe additional qualifications. Residence for voting purposes not lost or gained. Recall of officers authorized. I swear it was in here. Maybe it's in the code. Oh, no, it's right here. Forgot. State, inseparable part of the Union. The state of Idaho is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. Okay, that's right in our Declaration of Rights. It's the supreme law of the land, which means due process of law. So, back to the First Amendment, right? And the right to petition. Petition the legislature for the redress of grievances. It's a right and power retained by the people. Period. Okay. Mason's Manual Legislative Procedure, right there. The right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. All right. Election petitions. Now, this is Lex Parliamentaria Americana by Luther Cushings. This is the law regarding the legislative branch. This book, okay. Oh my gosh, it's not on this page. Oh, surprised. Oh, there it is. See that one right there? Cushing's Legislative Assemblies, blah, 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 blah. That's this book I'm reading from, Cushing's Legislative Assemblies. It's all over in the Mason's Manual Legislative Procedure because that's the authority. This particular book here comes from the common law. Parliamentary practice comes from the rules and the practice of the common law. Part of that fundamental law of how we do things in our republic. So, in the House of Commons, a system proceeding has been established by the series of statutes enacted in the year 1770. Real statutes. Those statutes at large. And since, for the trial of all controverted elections and returns, according to which cases coming within the statute description of election cases are required to be determined, petitions relating to cases of this sort, technically called election petitions, are presented and delivered in at the table as a matter of course and without any question. This is how we do parliamentary practice. This is how we follow due process of law. Subsequent proceedings are required to be instituted thereon according to the mode provided by the statutes, and no other mode of proceeding would be legally valid or have any legal effect upon the return or election thus brought in question. None. There's only one proceeding, and it is required. Petitions referring to or involving an inquiry into the merits of an election. That would be an audit. But which nevertheless do not possess the characteristic features of an election petition, cannot be proceeded with in that manner, but only according to the ordinary course of proceeding. Hence, it is sometimes a question of importance to determine whether a petition which has been put into the hands of a member to present or is not technically an election petition. If it is, it should be presented and proceeded with in that form. If not, it should be presented in the usual manner. So, if it's labeled as an election petition, it must be proceeded with in accordance with the statutes regarding the merits of an election. That's that inquiry into the merits of an election. When, therefore, a petition has been presented as an election petition and on the attention of the House being called to its contents, it appears not to come within the technical description of an election petition. The practice is to allow it to be withdrawn in order to be presented in the usual manner. If an order has been already made for taking such petition into consideration on a given day, it would be proper previously to discharge the order, though allowing the petition to be withdrawn would doubtless be equivalent to a discharge of it. In other words, to take leave and fix your petition if it's not proper. But see, again, this is why we have to do these in proper format. If it's not in proper format, it can be refused. Something I tried to say a long time ago. A certain somebody didn't want to listen to me, even after they were told. On the other hand, when a petition is offered to be presented in the usual manner and upon examination of its contents appears to be an election petition, or in substance, an election petition, it may be withdrawn in order to be proceeded with, according to the statutes. Or if a petition is presented and read in the ordinary course of proceedings, and upon the reading, it appears to be an election petition and is within the time limited by the seasonal order of the House, which is 2 years, it may then be proceeded upon as such. It is presumed, here's that presumption, that if a petition, which has been proceeded upon in the usual course, should at any time be discovered to be an election petition, the House would at once vacate or rescind all orders and proceedings relating to it and allow it to be withdrawn. Yeah, that's right. So it must be labeled as an election petition. Where a petition was presented and read in the usual manner, and the doubt then arose when it was not an election petition, the Speaker, Mr. Manderson, said, if the House were clearly of opinion that it was an election petition, the regular course would be to withdraw it for the purpose of, again, presenting it in that form to be taken into consideration in the usual way as an election petition, right? If the House were not satisfied on the subject, the most judicious way would be to adjourn the debate to give members an opportunity to look into the petition and to make up their minds. The debate was accordingly adjourned and the petition ordered to be printed. On resuming the debate, the House resolved that it was an election petition and made the usual orders. That's right. Order to conduct investigation. That's what's been going on down there in Maricopa County, you know. It's already been discovered. It's already been done through the legislature. This is how it's done. Here is the law behind it. It is a general rule that no discussion can be permitted to take place in the House which may incidentally or directly affect the proceedings upon an election case or prejudice in the House and thus tend to affect the committee with relation to at any point involved in such case until after the decision of the committee. The same rule applies, and for the same reason, with regard to petitions involving inquiries into matters connected with the merits of an election. If a petition complaining of such election has already been presented and is pending, no other petition involving inquiries which may affect or prejudice the trial of such election can be received until the election is determined. So see, it only takes one petition. That's all it takes. And no other petition can be presented while one is pending. If no election petition is pending, then, in order to prevent the receiving of a petition which may affect or prejudice a case which may probably arise, such petition must appear to involve matter which can alone be tried by an election committee. In the former case, the petition may be received when the election has been determined. In the latter, it cannot be received at all unless presented as an election petition. So, from the book, from the letter of the law here, what it says as it is written. So there's quite a bit more to this, right? petition charging or implicating members. Okay, that's the end of the election petition. Now we have a petition charging or implicating members. Imagine that. When a petition is presented containing matter of charge against a member or implicating in any manner his character or conduct for the purpose of parliamentary inquiry, it is necessary that such member should receive notice beforehand of the time when the petition is to be presented, in order that he may then be in attendance in his place and have an opportunity of vindicating himself, if he sees fit, against the attack upon him at the time when the charge is made. Wow, this is going to the legislature? That's right, folks. Legislature is where our powers are exercised, not the judicial branch. Okay? Oh, yes. This book is loaded with good stuff. Now, we'll go back up. That's 466. We got to go way back up here to the beginning of petitions, which I've already covered this before, but great refresher. Beings were right here. And what just happened today out in Meridian, and what's been happening, people, what do we do? What do we do? What do we do? Here it is. Here's the letter of the law that tells us, dictates how we exercise the right. Because see, our rights dictate, not the statutes, not the code, not the rules of procedure, the law of the land, due process of law, and our rights dictate. Okay, there's petitions and their substance. This should be petitions and their form. Oops. Be the next one. This lays out the form of the petition. As to the signing of a petition, okay, this talks about the general requirement with the reference to the signing of petitions as expressed in the resolution of the House, that all petitions presented to the House ought to be signed by the petitioners with their own hands by their names or marks, to which there appear to be 3 exceptions. First, where petitioner is unable from sickness to sign his name or mark, in which case another person may sign for him at his request or by his authority or consent. Second, where petition is all in the handwriting of the petitioner, in which case if his name appears in the body of the petition, it need not be signed at all. And third, where a petitioner, being out of the realm, has sent a full and legal authority to another to subscribe his name for him, that would be a power of attorney, in which the case the petition may be signed in the usual manner by attorney. That's right. So hope that answers the question over there on Telegram. Well, can we just, do we have to sign it? Yes. So that was the beginning of the parts there, but we got to go all the way back right there. Petitions as to their form. But we're going to go back up for a little bit of history on the right. Little preamble, precursor. All right. Chapter 7 of petitions. Of the right of petition. That is a right retained by the people. It is chiefly by means of petitions that the people, in their character of constituents, are brought into communication with the 2 houses of Parliament, and especially with the House of Commons as their representatives. So far as the legislative body is elective, so far the constituents, by their votes for particular candidates, express their opinion of public measures and policy. In certain cases also, and to a certain extent, and for particular purposes, they have the power to instruct their representatives. Well, I'll be darned. It's what it says in Article 1, Section 10 of our Declaration of Rights in Idaho. But neither of these modes of communication is adequate to all the occasions on which it is desirable that the wishes of constituents should be made known to the representatives. Petitions alone enable constituents to resort to the representative body. Whether in the judgment of any one or more of them, it is necessary or proper to do so with reference to any matter, either of a public or private nature, which is within the jurisdiction and functions of the legislature. The petition is an instrument in writing addressed by one or more individuals to some public tribunal or authority, in which, on the ground of certain facts therein set forth, the petitioners request the official interference of such tribunal or authority, either for the particular advantage of the petitioners or for the correction of some public grievance. When the object of a petition is a particular benefit of the petitioner, it is a private petition. When it is for the redress of some public grievance, in which the petitioner has no particular or individual concern, the petition is a public one. Now, when we're talking about public grievance, this has to do with public servants or public money. In both cases, a petition may emanate from a single individual, or it may be the act of as many persons as have a common interest in the subject and are willing to unite together for the purpose of prosecuting it. Oh, those are some pretty powerful words there. That's right, because we have the power to prosecute our own claims. Or there may be as many separate petitions relating to the same subject as there are individuals. Or there may be several similar petitions, each signed by several persons. So it doesn't matter. We can do one petition and have a buttload of signers, or we can have several petitions signed by several different people, relatively the same subject, right? Or we can do all completely independent petitions. Let's keep it simple, stupid. Let's keep it so simple it's frickin' stupid. One petition, let's get everybody to sign on, and we'll do it. Okay? The right of subjects to petition their rulers. See, again, this is back for English common law, but this is also for America. Okay, this is the Cushing's manual, right? But we'll have to take this in stride here. The right of the subjects to petition the rulers for a redress of grievance, either public or private, is acknowledged as a fundamental principle of the English Constitution and has been uninterruptedly exercised from the earliest periods. Imagine that. The right to address the two houses of Parliament in this manner is coeval with their existence, but especially have petitioners applied themselves to the House of Commons, who, as the more immediate representatives of the people, have always, in the forcible language of Mr. Speaker Abbott, opened their doors wide for receiving the petitions of all His Majesty's subjects with respect to grievances, whether real or imaginary. It don't matter. Even if we're totally nuts and out of our mind, just imaginary, it still has to be entertained. This right rests on no written charter like that of petitioning the crown, but, as was said by Mr. Fox, no man could question the subject's right to present petitions to their representatives, because it was idle to suppose that when a stipulation had been made by the Bill of Rights that the subject should, in all cases, have a right to petition the crown, they had not an equal right to petition the House of Commons, their own representatives. The right of petition is stated in the following terms by Mr. Hatzel: to receive and hear and consider the petitions of their fellow subjects when presented decently. Now, here's the key: decently and containing no matter of intentionally offensive to the House, is a duty incumbent on them and descendant to all rules and orders that may have been instituted for their own convenience. Justice and the laws of their country demand it from them. Remember, this particular part's about the history of the right. So it's giving us the lowdown that this right's been around for a long time. There can be no doubt that in this country, the right of petition is as sacred and as well established as it is in England, even where it is not secured by constitutional provisions. Imagine that. But in all the American constitutions, except those of the states of Virginia, North Carolina, South Carolina, Georgia, and Louisiana, it is secured in the amplest manner, usually in the following terms contained in the Constitution of Florida, namely, the people have a right in a peaceable manner to assemble together, to consult for their common good, and to apply to those invested with the powers of government for redress of grievances or other proper purposes by petition, address, or remonstrance. Now, there are a lot of them that say that. Tennessee is one of them. Florida is one of them. Idaho is not. But see, there's a difference between a petition, a remonstrance, and the address. The address is verbal. You know, that 3 minutes you get to speak on something, that's the right to address. Also, we get the right to speak to them. Even if after we file our petition, we have the right to address them. Now, a remonstrance has to do with policy that's in the middle of being made. Okay, that's a remonstrance. That's objection to them passing the bill. That's what a remonstrance is. A petition is a political lawsuit. Okay, that is the difference between those three things. And again, a petition, well, we'll just go down. It is with respect to measures of public character that the right of petition has been deemed the most sacred and has been guarded with the most care. Really? Hasn't been done in a long time, has it? Except for out there in New Hampshire. Hasn't been done properly anywhere as far as I know. People don't want to listen, that's fine. I'll do it right. As it is by this means only that constituents can express their opinions upon great national questions and bring their opinions to bear directly upon the legislative power. Petitions of this description do not rest upon the testimony of witnesses for their facts, nor do they trust to the ability and eloquence of counsel for their arguments and illustrations. Aha! They are simply to be regarded as expressing the deliberate convictions of the petitioners upon facts which are notorious or accessible to all, and founded in arguments and considerations which appeal to the reason and judgment of all. In other words, we do not need a member of the bar to represent this for us, nor make our arguments for us, nor interfere with it in any way, shape, or form. Kick rocks, get off my property. This is my right, and I will exercise it how I choose to exercise it within the law. The legitimate effect, therefore, of the representations depends on two considerations, namely, the influence which popular opinion is entitled to have upon the acts of government, and upon the facts and arguments which petitioners bring forward in support of their opinions. These are interesting topics of inquiry, which, however, it would be out of place to consider in this treatise any further than may be necessary to determine what proceedings ought to take place with reference to public petitions, in order that they may have their proper effect. So far, then, as the first ground is concerned, it is important to know the number, the character, and the situation and circumstances of the petitioners. Imagine that. The degree of deliberation with which their opinions have been formed, the ability which they possess for judging of the subject, the means that have been resorted to for obtaining their signatures. Like right now, what means have I resorted to for signatures here? Education. I'm providing the law behind all of this. So any man of sound mind possessing logic and reason shall come to a reasonable conclusion based in reality that this is how we do it, because that's what the letter of the law says. Not my opinion. These are facts of law, and I'm showing them to everybody out there. So there's no reason to argue with me. You'd be arguing with the letter of the law. You'll lose that. You'll lose that argument. That means that the means that have been resorted for obtaining their signatures, the freedom or constraint with which they may have acted, and to have regard also to the nature of the subject as being one upon which discussion by an intelligent and conscientious body of representatives can throw much or little light. In regard to the second ground, the facts and arguments adduced by petitioners, they are of equal weight and are consequently entitled to equal influence. Whether the petitioners be few or many, and whatever may be their condition or circumstances. So, if we get a lot of medical professionals to sign off on this petition to redress the grievances with these employers who are making a policy and have business practices that are contrary to Article 1, Section 1 and Article 1, Section 4, in direct violation of Article 11, Section 8, 7, and 8, their goose is cooked. Let's continue to read. If the views above expressed are correct, it is manifest that the right of petition on the part of constituents requires nothing more, as a matter of parliamentary duty on the part of representatives. That's right, they have to discharge the duties as we instruct them to do. Pay attention here. On the part of representatives, then that they should receive all proper petitions and should allow the contents to be brought to their knowledge in the fullest manner. If anything further than this is demanded, if it is urged that the voice of the people, as expressed in their petitions, ought to prevail, and that the legislature ought to do whatever it is required by numerous bodies of petitioners to do, then the deliberative faculty of the legislative body must necessarily be destroyed. For its duty would be to attend to the demands of the people, not for the purpose of weighing and considering them, but for that of granting them without any consideration or deliberation at all. What effect the petitions of the people ought to have upon the deliberations and conduct of their representatives is a question which does not belong to the subject of this treatise. Bingo. In other words, sit down, shut up. We're the master. We're here to dictate to you what we want you to do, and you're here to discharge the duties of your office and grant relief. Do as you're told, so long as it's proper and we remain in honor. Okay. No, a petition is a political lawsuit where we get to make demands for relief. A protest is a formal written declaration declaring something unlawful is about to happen or something unlawful has happened. Hopefully that clarifies that out there. It is only in the character of petitioners that constituents are in strictness entitled to offer their opinions and views regarding public measures to their representatives. Okay. It is only in the character of petitioners, not the petition, that constituents are in strictness entitled to offer their opinions and views regarding public measures to their representatives. In a petition, the statement of the petitioners are received as a ground of a prayer which they make. A prayer for relief is where we make our demands. A memorial, which is similar in its statements and allegations to a petition, but is unaccompanied by a prayer, is said to be objectionable in point of form because it assumes to speak as an equal and to advise the legislature as to its duties without any particular object in view. But such papers have nevertheless been received as petitions when there was no other objection to them, but in point of form, and they contain language equivalent to a prayer. Now, a remonstrance, which may be regarded as a similar representation unaccompanied by a prayer and intended to express opposition to the passing of some act or the adoption of some pending or contemplated measure, is equally objectionable in point of form and for the same reasons. Papers with this title, when drawn up in respectful language and amounting substantially to a petition against some proposed or pending measure, have been received as petitions. But in general, it appears to be the usage, especially when the object is to call in question the proceeding of the House, to reject papers of this description. A protest is similar in character to a remonstrance, but expressed in stronger language. A declaration against any measure does not seem to be different from a protest or remonstrance. See, there it is. Papers bearing any of these titles, if they contain a prayer, are received as petitions. If you're demanding some sort of relief, whether public or private, it is going to be considered a petition. A remonstrance is about some act that they're preparing to make in the process of making some resolution. Okay? So there is a huge difference there. The petition is an actual lawsuit. All right. So this is, whoops, did I pass it? No, not yet. Should be right here. Okay, of petitions as to their form. Let me see. What? I thought it said it was in there. Let's see. Oh. Let's go to Idaho. Yeah. Just a quick peek. Now you'll notice in this petition, it does say a remonstrance and petition. So I'm probably actually going to get rid of the remonstrance part, but this is the proper form in accordance with what I'm just about to show you there. That is diploma font at the top. That makes this a lawful document. Who it is addressed to? In the 66th General Assembly of the State of Idaho, to the Honorable, the General Assembly of the State of Idaho. The title of the document is a remonstrance or petition. Now, the status of me. The humble petition of Kirk Pendergrass humbly sheweth. Kirk's Law Corner LLC, doing business as KLC Media Group. There's my license number. Idaho Notary Public. I am an officer of the state. There's my license number there. On behalf of all similarly situated and all undersigned. I'm citing jurisdiction. Article 1, Section 2 and 10. Under the Joint Rules 2 and 6 et al. Mason's Manual Legislative Procedure, Part 3, Chapter 15, Section 148, Subsection 4. The petition is presented to the body of the petitioners themselves. And what did I just cover? Part 10, Chapter 73, Section 795, Subsection 10, to demand an investigation. Okay? So that's the kind of basic format, the caption portion of the document. This is what a proper form of a petition looks like. Okay? So, for tonight, that's all we got. Now, I hope that was very educational for some certain people out there tonight. Hopefully you're watching. If you didn't get to watch it live, maybe you'll go back and rewatch it. I'm hoping that you will. I told you I was going to do it. I'd lay it out. There it is. So I hope you enjoyed the show tonight, the education. And if you're enjoying learning from me and what we do here at Kirk's Law Corner, if you'd like to help support channels and help pay the bills, be greatly appreciated over at the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. I want to thank everybody who has donated and helping and supporting, keeping the lights on. But it's time to get serious, people. You want to talk about standing up? Here's an old saying for you. Do you got a leg to stand on? Or the old saying is, you don't even have a leg to stand on. You have to have a right to a cause of action here, folks, or you don't have any standing. That's the key. Well, I want to do it and I want to do it. Okay. How were you injured? Where's the loss or harm that happened to you? Well, there isn't, so that you don't have a cause of action. And yes, I actually started today a Telegram channel. So you can find me on Telegram. And it would be, if I can remember, it is KLC Media Group. So I have started that one up for those of you that are on Telegram that want to join and get the inside, a little bit of inside information there. The other way is Patreon. Okay. Patreon.com/Kirk's Law Corner. I do Wednesday night workshop for my patrons. And we discuss all sorts of good things in there that we can't discuss on here. So, if you're not on Patreon, want to get on there and get in on Wednesday night workshop, that'd be great. I want to thank everybody over there on Patreon right now. And boy, we've been having some good combo. And there's a little bit of something in the works through there too. So, some good stuff coming out of there. So I greatly appreciate my patrons over there. And of course, all of my followers here, both Facebook and YouTube. I'm almost 20,000 followers on Facebook and over 7,000 followers on YouTube. So we're getting up there. So thank you all for being part of this. And thank you for being here right now. For those of you that can make it right now. I know that some of you other times work better for you than this time, but you get to watch it later. Sucks not watching it live, but hey, still get to learn all the same, right? And of course, want to thank all the behind the scenes team members here and there and over there and down over there, Colorado. And yeah, want to thank all of you all. Thank you for being there. Couldn't do all this without you. And again, all you American patriots right here, right now. Okay. This is our time. It is our republic if we can keep it. And like Trump said at his inauguration speech 4+ years ago, I'm putting the power back into the people's hands. All political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary, and that is done through the legislature, not through the judicial branch. And if we can't get our legislature to convene, we file criminal complaints in the executive branch. We still don't go to the judicial branch. That's what they're there for. Okay? So that's part of more of the stuff that we're going to be getting into on Patreon. Okay? And again, thank you all for the Born Day wishes there. Thank you to my team and family for being up there for camping. And of course, my brother, who really not on here at all, but I'll just put that out in the universe. So let's get with it, American patriots. We had enough of this crap or not? We going to do something about it? Or are we just going to sit around and talk about it? Are we just going to sit around and moan and complain about how they can't do that and how they're violating our rights? I actually didn't catch any fish. I tried. They're just way too far out, further than I can cast. But yeah, I tried. So it's up to us, folks. All of the power is inherent in the people. When are we going to start claiming and exercising that power and instructing our representatives to alter, reform, or abolish this crap that's not supposed to be here to begin with? But make no mistake, I've got my own stuff in the works that's on the bigger stuff. But, you know, not everybody can have the knowledge that I have. But y'all can at least take care of your own personal affairs. And you can come together. We can work together. I can help you. Right? This is what's happening. So, thank you again for being here, American Patriots. We can't do this without you. It's time to step up. All right? And again, I'll put a plug in out there for Tony Pellegrino putting together the 4th annual We the People Idaho event, October 30th. Same place as the last 3 years, out there at the Convention Center, Civic Center in Caldwell, or the Nampa Civic Center, pardon me. It's close. But I've spoke with the last 3. I'll be speaking at this one again. And hopefully I'll have some things, special stuff to share this year. Things are in the works already. We'll see what happens here shortly. Some of you may know already what's going on there, but those of you paying attention, we'll see you. We'll see you there. Consider coming into Idaho for the event, because there might be a very special guest speaker. I'm working on it. We'll see. Blow your mind who might come this year. So, much love, everybody, and we'll see you on Friday night fun night, except for those on Patreon. We'll see you Wednesday night for Wednesday night workshop, all right? Much love, everybody. Have a wonderful night, and we will see you Friday night fun night. Good night, everybody.